Hello, I'm Robert Fetgather, retired clinical psychologist and adjunct professor of psychology. In this show, we're going to be talking about a very critical topic, elder abuse. We'll look at it from the perspective of a special type of elder abuse, one that is not commonly understood. It's oftentimes protected by courts and by law enforcement. As we begin to unpackage this type of elder abuse, I invite as my guest tonight Linda Kincaid, who is co-founder of the organization, the Coalition for Elder and Dependent Adult Rights. Linda, welcome.
Thank you.
So Linda, what brought you into your work with advocacy for elders?
I didn't come voluntarily. I had a very comfortable career as a safety consultant for high-tech companies in Silicon Valley. Life was going very well until 2010, when my mom became a victim of abuse. My mom had developed advanced Alzheimer's at that point. She didn't know where she lived. She didn't remember her phone number. She became suspicious of the person who was living with her and taking care of her. She became very suspicious of me. At times, she didn't even recognize me as her daughter. She imagined there were strange people in the house. She imagined people stealing from her, all the things that happened with Alzheimer's. Now, in this period of time, when my mom didn't know that she had over $1 million in liquid assets, didn't recognize me as her daughter, two of her tax preparers broke in her front door and took her and all of her financial records from the home. And of course, they quickly closed out her bank accounts, transferred her money into different accounts. And one of the first things they did just a few days after kidnapping her was to get her to an attorney. And they had her revoke her existing estate plan that she'd had for 2 decades. And they had her execute a new estate plan in favor of a step-granddaughter. And a few days after that, they placed her in an assisted living facility and gave the facility instructions not to let my mom have any contact with loved ones. No visitors, no phone calls, no mail. She was completely cut off from the outside world.
Well, that's outrageous. Did law enforcement intervene?
Not in the way we would hope they would. That was San Bernardino County Sheriff was the law enforcement agency we were dealing with, and they determined that because my mother went willingly with these two tax preparers that she had known for years, therefore it was a civil matter, it was not a crime. And because she executed a new trust, they said those must have actually been her intentions. And they said she's entitled to make any changes that she wants, and they completely ignored the fact that she was taken away at a time when she did not understand what she was doing, what was happening to her, and that she changed all the plans that she had been counting on to take care of her in her old age. So no, law enforcement did not help. In fact, the deputy who did the investigation had quite a screaming fit at me. He ordered me not to call my mother. He threatened to have me arrested if I went on the property where my mom was being held, the assisted living facility, and he threatened to charge me with a crime if I reported him.
Well, law enforcement was absolutely no help at all. What about Adult Protective Services?
Well, at least they didn't threaten to have me arrested. Adult Protective Services investigated, substantiated the abuse, and then they closed the case and walked away. We went to the long-term care ombudsman, who also substantiated the abuse, closed the case, and walked away. Actually, the ombudsman told me that if I wanted to see my mom again, I should go to court. And the third agency that you're supposed to involve is community care licensing. And I have to give them points that they actually did issue a citation to the facility for violating my mother's rights, but there was no penalty attached, and they cleared the citation without requiring any correction. So it was completely useless.
What about the courts?
The courts were frightening. We did eventually get to see my mom. It took us, I believe it was 16 court hearings over 15 months and cost $70,000 in legal fees to get a restraining order against continued isolation abuse. So we did eventually get to see my mom again. But as far as intervening in the abuse of my mom by the people who were holding her, there was no intervention. The court decided that this was a dispute between family members and would not engage in anything to help my mom. The caregiver records show that my mom slept on a mattress on the floor. A woman with $1 million was sleeping on a mattress on the floor. She didn't even have a bed. The doctor's notes talk about her wasting, not getting enough to eat. She didn't have routine medical care. She didn't have routine dental care. We spent about $400,000 bringing motions to the court trying to get my mom out of the facility where she was being neglected and abused, and the court wouldn't budge, would not do anything to help my mom.
My goodness. Did you ever consult the district attorney?
We gave mountains of evidence to the district attorney. In that evidence were caregiver notes that talked about my mom being terrified of a male caregiver who worked alone at night in the dementia unit. This man was alone with all of the women in there every night with no one supervising him. And the caregiver notes show that my mom was terrified of him. She was especially upset around personal care, bathing, toileting, dressing. The caregiver records show that she fought, screamed, begged for help. And the facility responded by increasing doses of Ativan, Seroquel, Haldol, antipsychotic drugs, and anti-anxiety drugs intended to calm her down, keep her quiet, make her more cooperative. This went on for about a year of increasing agitation, escalating chemical restraint. And after about a year of this, the medical records show that my mom was taken to the emergency room by ambulance for vaginal bleeding, genital trauma, and severe agitation. The medical records show that she begged for help when she was in the emergency room. The doctor actually wrote that she said, "Help me, help me, help me." She was screaming and crying for help. And the ER discharged her back to the facility. After she got back to the facility quickly transferred her out to another location. They terminated the male caregiver, and they conveniently lost about 6 weeks of staffing records. Those records just don't exist anymore, it seems. Our attorney located the male caregiver, took his deposition, and asked him directly if he ever sexually assaulted my mom. The male caregiver exercised his Fifth Amendment right, and he declined to answer the question. So we took all of that information and we gave it to both the sheriff and to the DA. The sheriff refuses to even talk to us. They won't even discuss the case with us. One deputy DA said there was no evidence of a crime, and another deputy DA said there was nothing out of the ordinary.
Nothing out of the ordinary? Are there other cases similar to your mom's?
Unfortunately, yes. I would like to think that this doesn't happen very often, but as I advocated for my mom and started speaking publicly about the things that were happening to her, other families came forward and talked to us about things that were happening to their loved ones. And we learned that my mom's situation was indeed nothing out of the ordinary. There was a case right here in Santa Clara County. Giselle Reardon in San Jose was imprisoned and isolated in an assisted living facility for over 2 years. The conservator in her case was the public guardian, which in a way is almost more frightening because that means that our tax dollars were paying for the public guardian to imprison and isolate Giselle Reardon, a woman who had done nothing wrong, committed no crime. But she had assets, she owned a home, and it was very convenient to keep her in a facility while they drew from her estate to pay for their fees.
Were you somehow able to break through Giselle's isolation?
Yes, Giselle's story actually has something of a happy ending. And it has a happy middle as well as a happy ending. I was able to get in and see Giselle. I went into the facility after hours on a holiday weekend when the B team was on duty. And they didn't stop me. I walked in and I found Giselle's room and I strolled in and sat down next to her and started talking. And I was able to have 4 visits with her over that holiday weekend, before the staff at the facility finally figured out that I was just a member of the public. And when they discovered that I was just a member of the public and visiting this person who was supposed to be held prisoner and isolated, they immediately ordered me off the property. One of the senior staffers showed up with 4 male staffers following her, and they glared at me and tried to look really big and ordered me to leave. And when I spoke to them about the residents' right to have visitors, the response of the senior staffer was, "Giselle doesn't have the right to make decisions for herself." And fortunately, I recorded all of the visits. I had my handy little recorder tucked in the side pocket of my purse, and I gave all of those recordings to the I-Team at ABC7 in San Francisco. And I invited them to come down and see if they could visit Giselle. And of course, their initial response was, well, nothing like that would happen to them. After all, they're ABC7. Dan Noyes has clearance to be in the Oval Office with the president. In fact, Dan Noyes has clearance to ride on Air Force One with the president. So there's no possibility that they would be denied access to this woman. I was like, come on, guys, just come down and see what happens. Bring your cameras and just come see what happens. And as the advocates predicted, the facility called 911 and had the police tell Dan Noyes from ABC that he was not allowed to see this resident in assisted living. And there's a wonderful clip that's now on YouTube that shows the police car pulling up to tell Dan Noyes that he's not allowed to talk to a resident in assisted living.
Well, Giselle gained some notoriety with Dan Noyes and ABC7. Was there legislation that was passed related to Giselle and your mom's case?
Yes, there was. In 2013, AB 937 was passed, and this was very memorable. This was the first legislation about a conservatee's right to visitation, and I was invited to testify before the Senate Judiciary Committee. I had the honor of sitting next to now Senator Bob Wieckowski, who introduced the bill, and we were involved in all the discussions and giving input on amendments to the bill. And 2013, the governor signed the bill 2 days after my mom died. And it clarifies that conservatees have the right to visitation, phone calls, and personal mail. This is not a new right. This bill did not create new rights. This is a right that we all have, and this bill simply clarified that conservatees retain this right. Then the next year, 2014, again working with now Senator Bob Wieckowski, he was then Assemblymember Wieckowski, he brought AB 2171, which was a statutory Bill of Rights for residents in assisted living. And again, it clarified the right to have visitors, phone calls, and mail, things that we all take for granted. This past summer, AB 1085 was passed, and let me read an excerpt of that bill. The legislature finds and declares that every adult in this state has the right to visit with and receive mail and telephone or electronic communication from whomever he or she so chooses, unless a court has specifically ordered otherwise. So this is the most progressive language in legislation in the country to date, clarifying that every adult has the right to visit with or communicate with anyone they wish.
Linda, great legislation. Problem solved?
Unfortunately, no. The caveat here is at the end of all of these bills, it says, unless a court has specifically ordered otherwise. And the intent was that if someone is being abusive, someone is taking advantage of the elder, then the court would be able to intervene and issue an order that that person who is perpetrating abuse could be prevented from having access to a victim. You know, the intent was clearly to help people. But this intent has been totally subverted by conservators who wish to continue isolating their conservatees. Anytime a conservator wishes to keep a conservatee isolated, which unfortunately can be fairly often, they simply go to court, manufacture some vague, ambiguous threat to the conservatee, and ask for permission to manage visitation or in some cases to limit the rights of the conservatee. And they generally get the order to manage visitation, and they manage visitation by denying all visitation, and that conservatee remains isolated, just as my mom was for over a year, just as Giselle was for 2 years.
Well, these kind of actions that are almost like violations of the law seem outrageous. Are there any other examples?
We have an example that's happening right now in Oakland. The case is Eleanor Frericks. She would now be 92 years old. She's under conservatorship of a professional fiduciary. A professional fiduciary, known as a profid, is a person who makes his living by managing estates or managing conservatorships. This isn't a family member. This isn't someone who does it out of the concern for a loved one. This is someone who makes his living doing this. Eleanor's conservator, a professional fiduciary, is keeping her isolated because she opposes the conservatorship and wants to end it. Let me go through the Notice of Conservatee's Rights here. This document, Judicial Council Form 341, is the Notice of Conservatee's Rights. This document should be in the case file of every conservatee in California. In the first paragraph, it says, every conservatee has all basic human rights and the right to be well cared for by his or her conservator. In the second paragraph, we have, the conservatee has the right to ask questions and express concerns and complaints about the conservatorship. This sounds like a reasonable right. If you're concerned about something, you should be able to address the court about it. And the third paragraph says, the conservatee will be allowed the greatest degree of freedom and privacy possible. And the narrative ends with, the conservator must give due regard to the preferences of the conservatee and to encourage the conservatee's participation in decision-making. The form then goes on to enumerate a number of rights that conservatees have. It starts out with, to be represented by a lawyer, to ask a judge to replace the conservator, or to ask the judge to end the conservatorship, make or change a will. Additional rights are to receive personal mail, to vote, to marry or enter into a domestic partnership, to receive visits from family and friends, to make his or her own medical decisions. These are all rights that the conservatee retains, and it's in this form that's in every conservatee's file, including Eleanor's. But that's not really the way things worked out. Here we have, this is a petition from Eleanor's conservator. He is petitioning for an order limiting the personal rights of the conservatee. In this petition, he explains to the court that he reasonably believes that Kenneth, Eleanor's husband, is trying to obtain a statement or a signature in support of his intention to vacate or terminate the conservatorship. Well, this Notice of Conservatee's Rights says that she has the right to ask to end the conservatorship. So the conservator is saying in his petition that she may want to end the conservatorship. Therefore, he requests that the court grant an order specifically limiting conservatee's personal right to receive visitors or telephone calls. So because Eleanor may want to terminate the conservatorship, he wants to isolate her from anyone who might help her do that. That's in direct violation of her rights. And we would assume that the court would say, stop, this is a violation of her rights. This can't happen. That's not what happened. The judge signed the order. This was September 12, 2014, an order limiting the personal rights of conservatee. And the court orders, conservatee's personal right to receive visitation is limited. Conservator is authorized to prohibit visitation. So with no due process, with Eleanor not being allowed to attend her own hearing about her rights, not being allowed to have an attorney represent her rights or her wishes, not being allowed to bring evidence, to give testimony, to cross-examine witnesses, without any of that due process that we all understand to be our right as Americans, her right to have visitors was taken away.
Why is there such resistance and obstruction to these rights?
Conservatorship is so very lucrative. We may wonder why this conservator is hanging on to Eleanor so tight. When this all started, according to her husband, her estate was worth about $6 million. Her estate is supporting the conservator's attorney, a court-appointed attorney, and a guardian ad litem, who is yet another attorney. All of those individuals are being paid from Eleanor's estate, being paid for their services for Eleanor. And in my mom's case, she didn't have a guardian ad litem, but she did have a court-appointed attorney, and of course there was a conservator, and there was the conservator's attorney, and a fair amount of legal fees, and all of those collectively have billed my mom's estate about $500,000 for a 3-year conservatorship. So these conservatorships are extremely lucrative.
Now, I understand that law enforcement figures into this. How so?
If law enforcement would enforce the rights of these elders, these abuses wouldn't happen. For instance, when my mom was isolated, when my mom was taken from her home, if law enforcement would have intervened right then and there, all of the subsequent things would never have happened. If when Eleanor is being denied visitation, if law enforcement would say, this woman has a right to have visitors. She has a right to be respected as a human being, as an American citizen. She has all the rights of any other person in this country. This type of abuse wouldn't be allowed to happen if law enforcement would respond appropriately.
Are there other major obstacles?
Well, there are 2 big obstacles that I see. The biggest obstacle involving law enforcement is law enforcement policy. CEDAR did a review of law enforcement policies throughout California, and we found that very few of those policies address elder abuse as a crime. They generally do not refer to penal codes. If you look at policies on child abuse, policies on domestic violence, you'll find many references to the penal code. It's very clear to an officer responding to a call that child abuse or domestic violence is a crime. There are penal codes associated with those actions. There are penal codes that should guide his behavior when he responds to those situations. But when the officer looks at the elder abuse policy, in most cases, he's not going to see any penal codes. He's going to see welfare and institutions codes. He's going to see health and safety codes. He may or may not see some probate codes. Those are all civil codes. Those are not the world that police officers work in. Police officers exist in the world of penal codes, and if a policy doesn't include the penal code, then the responding officer does not understand that this is a crime. And this is a huge problem for so many jurisdictions across the state.
What are some other obstacles, maybe family-related obstacles?
Well, let me tell you about some good news before we go on to more gloomy news. We worked with San Jose Police Department following Giselle Reardon's case. We had the same issue with Giselle Reardon. Police showed up, told Dan Noyes he couldn't see Giselle, told everyone they couldn't see Giselle because the guardian said, nope, can't see her, not allowed. And the police just assume that the guardian, the conservator, has that authority, even though they don't. So we were able to encourage San Jose Police Department, with some help from the civil grand jury, to update their elder abuse policy. And this was a real success story. San Jose PD now has an excellent elder abuse policy. It explains very clearly that isolation is elder abuse, and that elder abuse is a crime, and that officers are expected to investigate and enforce the law when they see elder abuse. This is a wonderful policy that could lead the way for the nation, and we are delighted that we were able to work with San Jose PD and help provide some guidance on that.
That is a huge accomplishment. What about misunderstandings about who perpetrates abuse?
Oh, that's one that we're trying to work on. Most policy, most training, most education on elder abuse is based on research that's 20 years out of date. There was a study done, 1996 data, by the National Center for Elder Abuse. The study was very limited in scope. It only looked at domestic elder abuse, or abuse in the home. And if you're looking only at abuse in the home, you'd probably expect that most of the abusers are family members. After all, if the elder is living in their own home, in the community, with their extended family, the people who have access, have opportunity, are that person's family members. And so it's not surprising that there would be instances of abuse perpetrated by those family members who live in the home. But if we move forward into the 21st century and look at more recent data, that's not at all what we see. MetLife did a study of financial abuse, and they found that of financial abuse in 2010, only 9% was perpetrated by family. And Cedar did a study looking at abuse of all types across all living situations. And we found that 24% was perpetrated by family. It does happen. But 38% of abuse was perpetrated by long-term care facilities. These are assisted living facilities, skilled nursing facilities, occasionally hospitals. So far more abuse was perpetrated by individuals who are being paid to care for a person than by their own family members. And that information has not yet made its way into policies and to training manuals.
Is there anything we can do to protect our loved ones?
I'm afraid there's not a whole lot. We certainly tried everything we could do to protect my mom. Giselle's family did everything they could do to protect her. We've tried to engage many different agencies and organizations to try to protect Eleanor, and that has all been unsuccessful. But what we can do going forward to try to protect our loved ones and protect ourselves as we get older is to engage with our legislators, to work with our state legislators to let them know that we want laws to protect elders, not just civil codes. We want penal
Well, Linda,
codes.
our time is just about up. Anything to close on?
I would like everyone to go to Cedar's website, look at the tab under Take Action for Free Eleanor, get in touch with us, and engage in our activities to help Eleanor get to see her family again.
Well, it's been a pleasure having you here this evening, and I hope those resources are helpful to many of our viewers.
Thank you.
Thank you, Linda.
It's